Hello everyone, and thank you for tuning in for this episode of Gough Square Live. I'm Ruth, Bala, and today I'm joined by Sabrina Goodchild, who's making her first appearance on Gough Square Live prior to becoming Chamber's new tenant in October. Today's topic is an update on unfair terms. I'm going to discuss two recent cases on negligence exclusion clauses, and then Sabrina will cover some other recent unfair terms cases. As always, this is being broadcast live. If you have any questions, you can post them on the live chat or send an email to goughsquarevl@gmail.com. The two cases I'm going to discuss both concern exclusion clauses covering damage resulting from negligence. I've summarised the relevant statutory provisions for business-to-business contracts on slide 1. The restriction is found in the Unfair Contract Terms Act, UCTA, Section 2. A trader cannot exclude liability for damage resulting from negligence except insofar as the term satisfies the requirement of reasonableness in Section 11. Post-CRA, that is the Consumer Rights Act 2015, UCTA subsection 2.4, back on slide 1, the third bullet point down, provides that Section 2 is inapplicable to terms in consumer contracts, i.e. there is no overlap between the regimes. Switching to slide 2 for consumer contracts, we look to the CRA. Exclusion clauses in consumer contracts covering damage resulting from negligence are simply subject to the general fairness test in Section 62, just like any other term. By way of reminder, that test is whether, contrary to the requirement of good faith, the term causes a significant imbalance in the parties' rights and obligations. Turning to slide 3, the first case I wish to discuss is Good Life Foods and Hall Fire. This is a Court of Appeal case from June, with Lord Justice Coulson giving the lead judgment. It concerned a business-to-business contract. Good Life has a frozen food production factory, and Hall Fire supplied it with a specialist fire suppression system. The main issue was whether Hall Fire's far-reaching exclusion clause was reasonable within UCTA. The fire suppression system allegedly included a defective component that actually caused a fire. Clause 11 of Hall Fire's standard terms is set out on slide 3. This purports to exclude liability for damage resulting from negligence. The final paragraph of the clause is important. It refers to an alternative package that Good Life could have purchased, including insurance. Lord Justice Coulson held that the exclusion clause was reasonable. A number of interesting themes arise. Firstly, the importance of insurance. Reading from the judgment at paragraph 76, the insurance point is at the heart of the reasonableness issue in this case. There are two reasons for that: the identity of the party best placed to effect the insurance, i.e. Good Life, and the express alternative identified by Hall Fire in the third part of clause 11. It was not unreasonable to include a wide-ranging exclusion of liability whilst also giving the customer the alternative option to pay an additional sum for Hall Fire to arrange insurance, which would enable Hall Fire to accept liability. In fact, Good Life had its own existing insurance against property damage, so this claim was being pursued by subrogation by its insurers. The second theme I've picked out is the relevance of industry norms. The court thought the exclusion clause here was in accordance with industry norms, and on that basis distinguished a 1990 case, Charlotte 30 and Croker, where a similar exclusion clause was found unreasonable. There is some precedent in other cases for reference to industry norms in determining fairness, not cited in Good Life, but how justifiable is the logic that if everyone else does it, it becomes reasonable? It could be said that a widely used exclusion clause is more likely to be anticipated by the purchaser. However, if we go to slide 2, UCTA subsection 2.3 provides that a person's agreement to or awareness of an exclusion clause does not itself indicate his voluntary acceptance of the risk. there's equivalent provision in subsection of the CRA 65(2). Therefore, the logic behind reference to industry norms appears to be that a group of traders is inherently more likely to act reasonably than an individual trader, even absent sectoral regulation, may be questionable. The third theme of interest is the approach of the courts. Pre-CRA, there had been judicial expressions, even in the Court of Appeal, see Granville Oil, of a lack of enthusiasm for UCTA's application in a business-to-business context at all. This scepticism was on the basis that businessmen were best placed to judge the commercial fairness of their agreements, and it was not for the court to interfere. Of course, there's no scope for such statements post-CRA, as UCTA's only application is to business contracts. However, Lord Justice Coulson stresses the importance of terms freely agreed by parties of broadly equal size and status. He also comments on the general recent trend in UCTA cases towards upholding terms freely agreed. It seems this trend is restricted to business cases, meaning that the application of UCTA is likely to be progressively cut down. This raises the question, not discussed in Good Life, of whether the different wording of the CRA and UCTA tests result in any meaningful difference. If anything, the CRA definition of unfairness seems narrower, a significant imbalance contrary to good faith versus not being reasonable, but inevitably more exclusion clauses will fall foul of the CRA by virtue of the consumer context. Ultimately, what matters is not the statutory wording of the test, but the court's consideration of all the relevant circumstances. If we go back to slide 1, it's part of the reasonable test in UCTA section 11 that the court has regard to the circumstances which were or ought to have been in the party's contemplation at the point of execution. Switching to slide 2, for consumer contracts, by CRA subsection 62(5), the court should take into account the nature of the subject matter of the contract, the circumstances at the point of execution, and the other contractual terms. So it's a balancing exercise. And this reality was best acknowledged by Lord Bridge in the classic case of 1983, George Mitchell and Finnilock Seeds, which was cited in Good Life at paragraph 27. What is fair and reasonable it's not accurate to describe such a decision as an exercise of discretion, but a decision under this provision will have this in common with the exercise of a discretion. The court must entertain a whole range of considerations, put them in the scales on one side or another, and decide at the end of the day on which side the balance comes down. There will sometimes be room for a legitimate difference of judicial opinion. So that to me sounds very much like the description of an exercise of discretion. It's a balancing exercise where there will be a range of possible outcomes. I shall deal more briefly with the second case on negligence exclusion clauses, which is at slide 4, Carney and Rothschild. This is a judgment from May of His Honour Judge Waxman QC, sitting as a judge of the High Court. It was a financial mis-selling claim. Only one strand is relevant to UCTA. The defendant bank had entered into loans with the claimants to provide funds for them to invest. The bank's representative allegedly misrepresented the level of risk associated with the investment scheme and its efficacy as a way of avoiding inheritance tax. The bank relied on the contractual terms at slide 4, providing that its relationship with the claimants was non-advisory. The bank said that these were basis clauses rather than exclusion clauses, therefore they could not be assessed for reasonableness under UCTA, i.e. they were out with the scope of UCTA. So the issue was one of taxonomy. Were these exclusion clauses or basis clauses? Basis clauses define the scope of the party's primary relationship, i.e. here by saying it was non-advisory. Exclusion clauses exclude an existing liability, i.e. here by saying to the extent advice is given, we're not liable for it being negligent. The court acknowledged that the functional consequences of basis clauses and exclusion clauses might be the same. However, in the same breath, the court said that the categorisation was a question of substance, not form. Query how that can be so if the functional effect of the two is the same. The court noted that basis clauses are generally unobjectionable in the commercial as opposed to the consumer context. That's a revealing comment. It again reflects the lack of any real substantive distinction between the two types of clauses. The court concluded that these clauses were indeed basis clauses, primarily due to the presence of other indications that this was not an advisory relationship, i.e. the clause was defining the scope of the parties' primary obligations. The court also relied on the fact that the clauses were not buried in the small print, although that's not an essential attribute of an exclusion clause, but rather goes to incorporation. Please note, under the CRA, the distinction between types of clauses would be immaterial because a term doesn't need to be classified as an exclusion clause to be subjected to the fairness assessment. So that concludes a busy 2 months in the appellate courts for UCTA exclusion clauses. I'll now hand over to Sabrina, who will discuss other recent unfair terms case law.
Thank you, Ruth. The first case I'm going to discuss is Andrikuk. If I could have slide 5, please. This is an EU case handed down on the 20th of September 2017. The Romanian Court of Appeal made a request for a preliminary ruling concerning the alleged unfair terms incorporated into loan agreements that provided for the repayment of loans in the same foreign currency as that in which they were dispersed. So the loan agreement was in Swiss francs and repayments were in Swiss francs, but borrowers received their income in Romanian leu. This had the consequence that the risk of fluctuations requiring an increase in the monthly repayments if the exchange rate of the Romanian leu fell against the Swiss franc was borne entirely by the debtors. Now, this case provides clarity on 3 important requirements of Council Directive No. 13 of 1993, which of course is the directive that the CRA and the Unfair Terms Regulations implement. Firstly, this case provides clarity on the interpretation of Article 4.2 of the directive. Article 4.2 provides that the assessment of the unfair nature of the terms shall relate neither to the definition of the main subject matter of the contract nor to the adequacy of the price and remuneration on the one hand, as against the services or goods supplied in exchange on the other, insofar as these terms are in plain, intelligible language. Now, the EU court held that the main subject matter covers the foreign currency repayment term, as I explained earlier, because the essential obligations of what the loan relates to is a sum of money, i.e. what is received and what must be repaid. And that sum of money must be determined by the stipulated currency in which it is paid and repaid. Now, this is quite a broad and wide interpretation of Article 4.2 that's also been utilised in the UK courts regarding the corresponding section in the Consumer Rights Act, which can be seen by the High Court case of Case Hub Limited and Wolf Cola Limited, which is a 2017 EWHC 1169 Chancery Division case. In that case, the term under consideration was a cancellation fee, which became payable if a consumer terminated their flexible storage solutions contract with the defendant within the minimum term. So the cancellation fee became payable as a lump sum equivalent to the total monthly charges remaining during the minimum term of the contract, less a discount of 10%. Now, the court in that case considered itself bound by the well-known Supreme Court case of OFT and Abbey National, and held that the cancellation fee formed part of the price payable under the contract, and so as against the services or goods supplied, not assessable for fairness. So what is clear is that serious consideration must be given as to whether a clause falls within the main subject matter of the contract or the price, as these terms are consistently being interpreted widely. Now, the second lesson to be taken from this EU case regards the requirement for contractual terms to be drafted in plain language. This case makes clear that financial institutions must provide borrowers with sufficient information to enable them to take prudent and well-informed decisions in order to comply with the requirement of plain language. Now, this effectively means that a consumer must be able to understand the actual effect of a term. So if a term is fair, but the effect is not clear to the consumer and they can't understand it, it won't be enforceable. Finally, this case provides clarity on when an assessment for the fairness of a term must be made. The assessment of fairness must be made by reference to the time of the conclusion of the contract, not during the course of the contract. So the assessment must be done taking into account all of the circumstances which could have been known by the seller or supplier at that time, and which were such as to affect the future performance of the contract. So if a consequence arises that could not have been known by the seller at the time of contracting, it cannot be taken into account when assessing fairness. The second case I'm going to talk about today is Indigo Park Services UK Limited and Watson. If I could have slide 6, please. This is a Scottish case where the term under consideration was any subsequent enforcement action may incur additional costs. You agree to indemnify us in respect of any reasonable costs and to make payment of them on demand. Now, this was a parking case, and the term under consideration only became relevant if there was a failure to pay the penalty charge for parking without payment. So if you failed to pay the parking fee, then failed to pay the penalty charge, you had to indemnify the owner of the car park for reasonable enforcement costs. Now, whilst this is a Scottish case, it's of interest given the fact that reported cases decided under the CRA are few and far between. When I checked last week, there are only 2 of any substance. Now, this case identifies a number of factors that may be taken into account when assessing the fairness of a term. Firstly, whether there was a legitimate interest in imposing liability. Secondly, whether the term is one which it would be reasonable to assume that the consumer would agree to if individually negotiating terms, even though the term hasn't been individually negotiated. Further, whether the consumer is left without protection. So in this case, it was found that he wasn't, because only reasonable charges were payable as opposed to charges full stop. Finally, whether the consumer had any other options. Again, in this case, it was found that he did, because he could have easily parked elsewhere. There are a number of different parking options, and he didn't have to choose to park in that specific car park and not pay the fare. It's also of note that the court found that the considerations on whether a term is a penalty overlap with considerations on whether a term is unfair. So this, of course, brings in the leading case on penalties of Parking Eye into play when considering whether a term is unfair. Finally, an update on guidance. The most informative guidance on unfair terms is, of course, found in the CMA's Unfair Contract Terms Guidance, published on the 31st of July 2015. Now, this guidance hasn't been updated since it was published, which is perhaps understandable as no amendments have been made to the relevant provisions of the CRA in that time. And the case law on unfair terms, as found, since publication has been highly limited. Looking to the FCA, having been steadily removing its guidance on unfair contract terms since 2015, the FCA in May of this year published a guidance consultation on the fairness of variation terms in financial services consumer contracts under the Consumer Rights Act 2015. The FCA's prior 2012 guidance has suggested that interest rate variation clauses would be upheld if the term provided that the variation would be for a valid reason, which was not specified in the contract. Now, this was flatly contradicted by the CJEU in the cases of Invitel and Vertrieb, and this new draft guidance from the FCA rationalises this by reminding us that the variation clauses which are not within the grey list nonetheless need to be transparent in order to pass the fairness test and to have effect. Now, the proposed guidance is targeted primarily at contract terms that give firms the right to vary contracts without obtaining consent from consumers, so-called unilateral variation terms. In its proposed guidance, the FCA set out a number of factors relevant to determining whether a term is fair, focusing, it seems, on legitimacy. So, for example, whether the term has been included to achieve a legitimate objective, whether the variation would be no wider than reasonably necessary to achieve a legitimate purpose, and whether there's a fair balance between the legitimate interests of the firm and the legitimate interests of consumers. And this proposed guidance also sets out example grounds for variation that may be specified in unilateral variation clauses. Some of the examples that are given are legislative requirements, changes in technology, and to remain competitive. And the guidance then assesses whether these grounds are likely to be valid. So, for example, the proposed guidance suggests that permitting variations as a result of changes in legislative requirements is likely to be valid. But permitting variations just to remain competitive is not. However, including a catch-all ground for variation at the end of the clause, for example, or for any other reason, is potentially valid if the contract is one of indeterminate duration. Now, this consultation is open until the 7th of September 2018, so if you want your views to be taken into account, you must make them known by that date.
I'm surprised they said that any other reason the catch-all might be permissible, reading it, even if just for indeterminate length contracts. It will be interesting to see whether such terms are challenged.
Yes, it will. Now, we've had a few questions on the live stream, but I think probably the one that I'm going to answer is what impact will Brexit have on unfair terms in contracts now and into the future? So obviously everything to do with Brexit is very unclear at the minute, and there isn't much guidance on this as of yet. But the EU directive that has been implemented in the UK by the Consumer Rights Act and by UCTA fully implements that directive. So it is now UK law. Even though it has roots in EU law, it is UK law. So whether we leave the EU or not, and when it happens, won't affect those two acts of the UK. What will be of interest is the effect that EU case law has on things going forward. I've referred to a few EU cases in my speech, and what is unclear is whether they will have any effect going forward from previous cases that were decided before the EU, and then cases that have been decided after Brexit. So at this stage it's very unclear what will happen, but that's not, unfair terms aren't alone. That's going to be the case for every CJEU decision that impacts UK law at the minute and in the future. Now, I think that's probably just about all we've got time for. So thank you very much for your speech.
Thank you for tuning in, everyone.
And there won't be another Gough Square Live in a few weeks' time because we are at the end of the season, but the new season will be starting in September. So please join us then for a next season of Gough Square Live. Thank you.